Hello, everyone, and welcome to this Employment and Immigration seminar. Thank you, everyone, for joining. It was rather hastily arranged. Martin Nicholson, I think you're on the call. Last week, you sent me an email saying, were we intending on doing a post-election update? And the truthful answer was, at the time, we weren't. Yet here we are. So thank you for that prompt. On the call, we have some old friends, some new friends, and some hopefully soon-to-be friends. Just for the latter category, very quickly, I want to talk a little bit about IBB in case you don't know about us. We are a 250 or so person firm based in West London and the Thames Valley. We are a full service firm, so we cover private client services, real estate services, and then the area that I head up, which is the commercial team. There are 50 or so of us dealing in commercial litigation, commercial work, GDPR, IP, and specifically for the purposes of today, employment and immigration. So the idea is for the next 45 minutes or so, we're going to try to deconstruct some of the Labour manifesto pledges, which were both within its manifesto and also the New Deal document that many of you have probably read, all of which is designed to implement the government's published aim of ensuring job security, fair treatment for workers, and their words, a decent wage. Whether we, could you just move to the next slide, please? Whether we, this is not meant to be a political comment. I know it's difficult after a couple of months of crazy electioneering. But where we comment, it is very much coming from our viewpoint of being employer-focused advisors. And as you would expect, we have some concerns about some of the things we have heard from that viewpoint. But we've been challenging things we're not sure about for certainly the last 14 years and before then as well. How quickly this is going to all come into force is a very interesting question. Some of the meatier subjects there's going to have to be a fair bit of consultation on. I'm going to deal with some of those. And we have previously, as a firm, got involved in the policy consultation. And indeed, we have also sought the views of our clients and contacts in that and provided, if you will, a consolidated response to consultation. So if any of you are interested in getting involved in that, please let us know, and we will add your name to the list. The timescales, well, the government has talked about the first 100 days. In fact, it's all very Franklin D. Roosevelt, isn't it? First 100 days, the New Deal. We'll see how quickly some of this stuff comes in. But at the end of the day, the government's got a big majority. They are very enthused to do these things. It formed a fairly important part of their manifesto pledges. And I suspect that the House of Lords will be a little reluctant to be seen as disrupting a government that has such a strong mandate. So I think we could see some of this come in relatively quickly. So the agenda and the speakers. So I'm going to deal with a few of the meatier topics and perhaps some of the topics that have caused the most discussion and debate, even though the details are a little sparse at the moment. I'm then going to hand over to Nicola, who will deal with sweep up the rest or most of the rest of the proposals that the government are planning to implement. And then in a slight change of plan, Richard Duval is going to deal with the immigration changes that may be in the pipeline over the next few years. Unfortunately, Samir couldn't make it today. She's not feeling too well, so Richard has stepped in. If time permits, we will take some questions at the end of the session. And what I would ask is that you pop the questions in the Q&A tab, and there is a slider there if you want your questions to be anonymous. You don't have to, but if you want them to be anonymous, then hit the slider, and your anonymity will be there. So I will then have a look at those, perhaps when Richard's speaking at the end, and try to see if there are any running themes on the questions. And try and deal with those. If we can't deal with any of them in the time that we've got, then we will probably do a consolidated answers to all the questions and send those out to everyone anyway. Right, so first of all, we have unfair dismissal. The main topic of discussion has definitely been the desire on the government's part to make unfair dismissal a day one right. And I'm going to come back to that in a moment. But there are a couple of other changes which look like they're going to come in. Firstly, extending limitation timescales. So at the moment it's 3 months. And this isn't just unfair dismissal on this point. This will be many claims as well. At the moment, an individual has 3 months to bring a claim, although in fact, and part of the reason I'm not sure about this change is that because of the claim conciliation through ACAS, actually a claimant can have up to nearly 6 months as it is. I haven't heard claimants screaming for this, or claimant organisations screaming for this deadline to be extended to 6 months. The manifesto or the New Deal policy referred to it specifically being perhaps for maternity returners who might need a little extra time, or people on maternity. And I kind of accept that might be right. But I'm not sure it's entirely necessary. However, I think there is a consequence of this, which I don't think is intended, which is I can see a world in which there are actually fewer claims as a result, however counterintuitive that sounds. And the reason I say that is because we know that most individuals, the main driving force around whether they bring a claim or not is whether they've got another job. Very often, that is the point that really matters. And actually, the longer a person has to assess that and assess their losses, either A, the less likely they are to bring a claim if they get a job relatively quickly, or B, if they do get another job, it crystallises the value of their claim. They know what the claim is worth. It's no longer open-ended, and therefore perhaps easier to settle that claim. So I can see a world, as perverse as it sounds, where an extended limitation timescale actually leads to fewer claims. The next point is the removal of the compensation cap. And this is an interesting one because I think unfair dismissal there are a few, but is one of a small number of areas where compensation doesn't fully compensate the wronged party. And by that, I mean, in the UK law, compensation isn't punitive. You get £1 million damages if you haven't lost £1 million beyond the discrimination, pain and suffering. But also generally, it's not capped. Generally, you are compensated for the losses that you have incurred or suffered. Is this going to have a massive effect on the awards in the tribunals? I suspect not. For anyone who's looked at the statistics, and the Employment Tribunals send them out every year, about average awards and maximum awards and mean awards and all the rest of it, the cap is actually not often used. Certainly the averages are well below that. I think where it will have a difference and an impact is the inclination or enthusiasm for some employers to enter into protected conversations, as used to be called without prejudice conversations. I think now the parameters of what an unfair dismissal claim is worth is very clear. There's a cap. And I think that drives most settlement discussions. Going forward, if there is no cap, then it may just be that employers are, as I say, a little less enthusiastic about having those conversations because they're worried they might end up having to write a blank check. And that's a bit of a concern for me. I think the protected conversations law, I was going to say new, it's not that new, has actually worked relatively well and worked for employees as well as employers. So we'll have to see. However, being fair-handed, I think one can see the strength in the argument that someone who's been unfairly dismissed should be compensated fully for the results of that unfair dismissal. As you can probably gather, this isn't the biggest headline of today, but I think it will have an impact, and I'm not 100% sure about it. Right, so moving on to the main item, which is unfair dismissal being a day one right. So the government has said that the reason it wants to do this is firstly to remove the arbitrary, effectively 2-year waiting period, probation period, whatever you want to call it, but also allow a freer movement of staff with workers or employees not being afraid to move because they will lose their most of their rights for the first couple of years. And also from an employer perspective, the government has said that it will allow employers to choose from the best possible pool because employees, again, won't be afraid to move. So all the employees will look for new jobs potentially. The government saying that getting a new job is the time that employees can best sort of enhance their pay. So it fits in with their decent wage headline. I have to say 2 years does feel like a long time. I mean, I've lived through it all. I haven't lived through the 6 months, that was before my time, but 1 year, 2 years. I think 2 years sometimes it does feel like quite a long time. Equally, day one, I am bound to say this, aren't I? But I think the danger is that businesses, and particularly smaller businesses, might be a little fearful when recruiting, and that is obviously not what the government is wanting to do, but that is the potential consequence, and I'll just say a little bit more about that later. But the big issue here is a probation period, because the government's made it clear that it will, I think it says it will still ensure that employers are allowed to assess performance in a probation period. Now, we just don't really know what that means. So it could mean that at the end of a probation period, and how long would that be? And will there be a model probation period which everyone's got to use? It could be that at the end of that period, the employer can effectively sort of almost automatically dismiss without process. It could be with an expedited process. It could be after a full process. We just don't know. But I certainly would welcome the ability for an employer to be able to dismiss in a more easy way after, say, 6 months. I think without that, I am concerned that that particularly smaller employers may just be a bit reticent to recruit, which is of course not what anyone wants. So I think there are still quite a few questions there. I think generally speaking, I can see that 2 years is a long time, and please don't shoot me. I know who the audience is today, but sometimes it does feel like a long time. I was talking to a client yesterday, and he said to me, well, it will, of course, drive good practice performance management. And he's right. He was with a company that does it well. Unfortunately, I think many employers still treat the first 2 years as a 2-year probationary period, but without any sort of paper trail. So I think moving on to what we can be doing now, Recruitment process is absolutely key to getting the right people. We all know this anyway. Whether the employers are going to have to look at slightly more in-depth recruitment processes with situational testing and potentially psychometrics, although one needs to be careful sometimes around anything that might be deemed discriminatory. But I think probably more rigor around recruitment is sensible anyway, and certainly may be necessary going forward. References. Probably the lawyers are to blame for this. I know a number of employees who aren't even bothering to take references anymore because kind of what's the point? I think it is unhelpful, the way the law has gone, and I do accept that I think us lawyers have not helped this situation. There's no simple answer. And some of you may say that, well, even references in the old days, if it was glowing, it was probably the result of a settlement agreement, and you may well be right. But I do think it's really unhelpful that 9 times out of 10, the new employer has no anecdotal evidence from an objective old employer. The next thing that's going to be really important, and is really important anyway, is a probation process. For me, it's an extension, and always has been an extension of the recruitment process. It's just the end of it, the bit where they're actually with you. It's so often overlooked. There's so rarely a good paper trail through the process. It may be, as I say, that the government will come up with a model probation process, however long that may be, with the steps you need to take. And to some extent, that might be quite helpful. But I do think we need to be taking these probation processes seriously. And the one thing I will also say is that you always, even if the employee has less than 2 years service, you always want a paper trail as to the reasons to dismiss. Because otherwise you'll be on the end of a claim, usually for discrimination. We call them not meant to be in a flippant manner, but kitchen sink claims, where an employee is searching for the real reason. They don't really think it's about performance, so they just put in a claim covering all the discriminatory things it could be. And so if we follow a probation process correctly, we should be able to extinguish those potential claims. As many of you have heard me say before, employees bring claims not because they have been treated badly, but because they think they've been treated badly. They feel they've been treated badly. It's all about perception. The last 2 bullet points there are, so firstly dealing with the last one, current workforce. We don't know how this is going to be brought in. Is it going to be retrospective? I kind of think it probably has to be, because otherwise a new employee would have more rights, ironically, than a longer serving employee who's still within the first 2 years. But equally, if it is retrospective, then the employer has lost the ability to manage out the employee during this probation period, whatever that means. And so employees with 12, 15 months service will have gained quite a lot of protection overnight. But I suspect that's how it will work. The ultimate unintended consequence, I think, often hyped. We've had this before. More hyped than reality is whether employers are going to be minded just to sack everyone who is. They're not sure about who's still within their 2 years service. I say that threat has been live before. I've rarely seen it happen. So that's unfair dismissal. We'll have to see what happens when we get more flesh on the bone. There's going to have to be some consultation about this, I'm sure. So moving on to 0 hours contracts. So as I say here, 0 hours contracts gone from hero to villain, really. I was involved in a test case on 0 hours contracts, probably 20 years ago, or for the best part of, with an employer who used them very responsibly in quite the right way. And the tribunal fully backed the concepts of the 0 hours contract. Since then, kind of everything's changed. I'm not going to name names for fear of litigation, but a number of high-profile organisations use 0 hours contracts when they didn't really need to. It wasn't really fluctuating work. It was fairly standard 9 to 5, albeit 7-day-a-week work. And then on top of it, some employers, and even as an employer-focused solicitor, I struggle to justify this, some employers wanted to put exclusivity in the contract. So we're not going to give you, or we're not going to commit to any hours, but you can't work for anyone else. And I think that was probably the straw that broke the camel's back. So the government are looking at banning exploitative 0 hours contracts. We don't know what exploitative means. It may be they're saying all 0 hours contracts are exploitative. It's not entirely certain what they mean by that. I remember as a student, I worked in a warehouse under a 0 hours contract. It suited me perfectly, but I was very conscious I was rubbing shoulders with people who had families to support, and they didn't know if they had work the next week. So what's exploitative for one person may not be for another. The government's going to have to set some really clear parameters around that. And I do feel there's a place for 0 hours contracts. I hope they don't go completely. I think used correctly and responsibly, I think they are a very useful tool in an employer's suite of contracts. And I do feel a bit as if a small number of people have ruined what is actually, in principle, a good concept. Fixed term contracts can still be used. The government specifically refers to that. So seasonal work, it may be, for example, you have a summer long contract. Agency workers, I don't know if we've got any agencies on the call, but I can see them rubbing their hands on a lot of the stuff we're talking about today. I know that agency workers obviously are protected as well, but I can see them being the beneficiary of a lot of this stuff. So moving on to what we can be doing. One-sided flexibility. I'm not going to talk too long about this. This is all part of the same issue, which is the government feels the employers are having all their own way around flexible contracts. So there is going to be a right to have the contract reflect the hours that an employee actually works over a 12-week reference period. Not completely new. The last government looked at that upon request, didn't quite get it through. And then reasonable notice for changes of shifts. The concern for me with all of this goes back to the small employers. Most people on this call are big employers, but for the small employers who genuinely have fluctuating work, I do have a couple of concerns about how this is going to play out for them, unless there is a way in which 0 hours and flexible contracts can be used in a responsible way. So moving on to what to do now, basically what you probably should be doing anyway, which is audit, review the use of all your flexible contracts and look at the minimums. Look at the minimums that you are using people on 0 hours contracts, because it may well be you can offer them a minimum hours contract. We don't really know where that's going to sit. Could a loophole be offer everyone 1 hour a week? It's not a 0 hours contract. I doubt that. But look at what the minimums are. Look at whether there are ways you can more efficiently use your workforce. Slight concern that it might actually lead to you using fewer employees because you try to make it more efficient with the ones you've got rather than having flexibility with more employees. But I think play out some of these scenarios, pretend if the government says no 0 hours contract, how does that look? If they said 10 hours at least a week, how does that look? Be ready. And then the final point there is I can't see this happening before the summer ends. So I think for those for whom they use 0 hours contracts as seasonal contracts, I think there'll be a time to reset, understand, digest what the government is saying, and then get it right for either Christmas, if it's Christmas, or next summer. So then moving on to the last point I'm dealing with, which is worker status. So in the UK, we have a 3-tier system. It's unusual. Most other jurisdictions have 2-tier systems. So we have self-employed, employee, and stuck in the middle, a worker. What is a worker? A question I used to lay in bed at night thinking about, until the rise of the gig economy, there were very few examples. It was easy to regurgitate the sort of the law and the definition, but there were very few examples. The law in this area is a complete mess. On that, I have to agree with the government. It affects a large number of people. We are constantly waiting for new law, and that law is always fact sensitive, words that I know you love it when us lawyers say. So even if a particular delivery rider is deemed a worker, doesn't mean an Uber driver or whoever else courier will be. And it's really it's really difficult. It's really uncertain, and frankly, it's not helped by the fact that the tax authorities use different tests to the employment tribunals. So all a bit of a mess. So what to do about it is perhaps the tricky one. So if we can move on, is it time for a change? Probably is. I'm reminded of the TUPE law, for those who remember it, in the early noughties, when the outsourcing thing was just a total mess, and no one knew whether an outsourcing was a TUPE or not. The government said, right, we're just going to say it is. A lot of people moaned, me included, but actually, I think net benefited everyone because there was just certainty. My concern is how the government is going to do this, where they're going to draw the line. Is it going to get underneath the falsely labelled relationships? Is it going to give clarity and certainty? Or is it just going to lead to even more case law, even more appeals? The definitions are going to be so important, and particularly around self-employed, because actually they're the people that really need to know where they stand. And what we've seen is a creep into self-employment, if you will. So more people who would have thought they were self-employed aren't, and it's not really very well defined. What I think might happen, given the New Deal policy document, is that in fact employees and workers will be lumped together and maybe even extended, and then the self-employed people will just be on the periphery at the end. I like the three-tier system. I think there is a place, again, responsibly used, I think there is a place for workers. I think the problem is, again, it's been abused, and it's a complete mess. I do slightly concern that throwing the baby out with the bathwater, just going to a two-tier system, but it will provide clarity, I guess. And I think probably once everything's defined, at that point we can have a look at what you can do about it. But in the meantime, have a look at your atypical workforce, and just again play around with some scenarios as to how this might affect you. So that's a whistle-top tour of my three big subjects. We will provide updates as I'm so conscious that that we don't have all the detail yet. We will provide updates as soon as we get them. I'm now going to hand over to Nicola.
Thank you, Justin. So as Justin said, I will now be looking at some of the other changes that the government are proposing. So as Justin alluded to, one of the things that the government is looking at is a genuine living wage. So currently we have the national minimum wage for those under 21, and the national living wage for those over 21. And as you can see in the slides, the rates and the ages are put up there. Now, these rates are set each year in April. So the current government are now proposing to remove the age bands as they see that it's discriminatory. And they also want to make sure that it is a real living wage that people can actually live on. So at the moment, the manifesto actually refers to adults receiving the genuine living wage. So I don't know if that includes the under 18s or whether they will still be at a lower hourly rate, which would still seem fair. They also intend to expand the remit of the Low Pay Commission, and which are the body that reviews and makes recommendations on the national minimum wage, and to ensure that they consider the increases in the cost of living when they do that. I think ultimately, since the government are looking potentially to bring this in, as Justin says, we don't know when, it may well be useful to start looking at your budgets, and certainly it would appear for those over 18, the national minimum wage, or the genuine living wage, will certainly be increased. So if we just move on to the next one, so sick pay. I know a lot of smaller employees especially just pay the statutory sick pay. So to be eligible for that, employees and workers must be earning more than £123 per week. And the first 3 days of any sickness absence are known as waiting days, which basically means that the employee does not get paid for that. And also at the moment, the SSP is currently £116.75 per week. So Labour's plans are to remove the lower earnings limit. So anybody, no matter how much they're earning, would be entitled to statutory sick pay. And also they will be removing the waiting period. So that's the first 3 days of sickness, which is currently unpaid. Again, I think in particular for smaller companies who don't at the moment pay any sort of enhanced sick pay or pay for those waiting days, there's certainly going to be an increased cost for them. And again, I think it's worthwhile for employers to sort of look at what their sickness absence policies are, and also to look at their sickness absence records, so they potentially can start budgeting and working out what the average cost may be when this comes into play. So if we then go on to sort of the family-friendly policies that the government are talking about. So at the moment, employees who have been employed for a period of 1 year can take up to a maximum of 18 weeks unpaid parental leave, and that has to be taken in or up to 4-week blocks, and can only be taken up until the child is 18 years old. So what they're planning on doing is bringing this into line with the flexible working requests and making it a day one right. Now, ultimately, I don't think that this is going to have any sort of major effect on employers, as ultimately parental leave remains unpaid, and so you don't particularly get a rush of employees asking for this. Then we've got bereavement leave. So ultimately they haven't said how they are likely to change this, but I've sort of highlighted it as they certainly feel that it's outdated and ill-defined. And so they would be looking at introducing some sort of right of bereavement leave to all employees. And again, we will just have to wait and see how this actually pans out. Then you've got the maternity and the government trying to provide additional protection to those when they come back from maternity leave. And so what they're suggesting is that for the first 6 months after the employee has returned from maternity leave, that you would not be able to dismiss them, and that you would only be able to do so in specific circumstances. Now, we don't know what those specific circumstances are. They haven't actually defined them. But it will be interesting to see if redundancy is one of those specific circumstances, because ultimately that's one of the ones that seems to come up in question. And then we've got the right to switch off. So apparently this has been used in other European countries, and we are sort of taking their approach and looking at it for ourselves. So it's all come about because of the ability to homework, and obviously then there becomes blurred lines between home working and your own actual family life, and maybe you don't actually switch off when you should. So ultimately what they are looking at is to ensure that employers are not contacting employees outside of contractual work hours, and to ensure as well and to encourage constructive conversations between the actual employer and the employee. Again, we would just have to see what will happen with this, but ultimately it could be seen as a positive move, and potentially employees will be more motivated because they've had more rest in between working hours. Just as an aside, it's not in the manifesto, but councils have been piloting the 4-day working week, and you wonder whether or not Labour will be more sort of sympathetic to those plans in the future. Right, so just looking at equality. So we've got the gender pay gap reporting. So that's obviously been in place for a number of years. But the government doesn't actually feel that it's moving quickly enough. And therefore, they're sort of expecting, or will be requiring, large firms to publish and actually implement action plans as to what they can do to close the gender pay gap in their business. Also, as well, when undertaking the gender pay gap reporting, employers are now going to be looking at, or need to be looking at, outsourced workers as well, because the government feels that employers are potentially outsourcing services to avoid paying equal pay, and obviously they want to try and prevent that. So as well now, companies with more than 250 employees will be required to publish ethnic and disability pay gaps. So pretty much in the same way, I mean, it's indicated that it'll be pretty much in the same way as the gender pay gap reporting, and ultimately then the government can sort of tackle any inequalities that there may be. Again, should you start preparing for this, it might be worthwhile to be looking at it in the same way that you do with the equal pay. And another thing for larger companies with over 250 employees is to actually produce menopause action plans. So what are these? So that's for the company to set out how they will actually support employees through the menopause, and will be sort of similar to the reports that companies should be doing for gender pay gap action plans as well. So the government are going to go further there in relation to sort of the menopause, and they are saying that they're going to publish guidance for all employees, large or small, on measures to actually consider when people are going through the menopause, which may be such things as uniform temperature, flexible working, and also how to record those menopause related leaves and absence. so that it doesn't come up as an ordinary sickness absence. And then if we just go on to the final point that I'm going to make, we've got redundancy. So this is more for those companies when you're making a number of people redundant, and in fact 20 or more employees are being made redundant. So currently we have the collective consultation rules when you're supposed to deal with employee representatives or trade union representatives and go through a whole consultation process. And the government are proposing to actually change that slightly. So at the moment, it's 20 employees being made redundant within a 90-day period at a single establishment. But they're going to actually increase that. So the numbers and the period of days remain the same, but they are talking about the entire business now. So that could be a number of workplaces for that company rather than just the one single establishment. So we've all heard a lot about the fire and rehire. So obviously, when you're looking to make contractual changes, the ideal situation is that you would be consulting with the employees about the changes that you wish to make to the terms and conditions. But obviously, we've all heard about the fact of when agreement cannot be reached, employers have gone down the route of terminating employees' contract and rehiring them on less favourable terms. So the government proposes to end that ability to fire and rehire, and have suggested that there will be effective remedies for those who abuse it, and also they will be introducing a strengthened code of practice. Again, it's very much a wait and see situation as to what will happen there, but certainly I think that the fire and rehire will be removed. And then we're just looking at the voice at work. So this is all about the government improving legislation around trade unions, so that workers then feel empowered to work with trade unions. And also they will be looking at providing additional protection for any sort of trade union representatives. They've also indicated in relation to trade unions that it will be included within the contract of employment, which they're entitled to on day one, and will have the ability, or will highlight that the employee has the ability to join a trade union. Right, I'm just now going to pass on to Richard, who will deal with the immigration changes.
Thanks, Nicola. Good afternoon, everyone. Apologies for the croaky voice. I think I'm guilty of shouting too much at the TV last night. So I'm going to talk to you briefly about business immigration and the possible changes coming forward. I think it's fair to say at this point, the Labour proposals haven't got a substantial amount of detail with them. But their primary focus is to reduce net migration by implementing a cross-department skills strategy, which hopefully will reduce the UK's reliance on foreign workers. It seems to me that a strategy like that is going to take a considerable time to effectively implement, not least because they have committed themselves to engage in consultation with employers before they actually put anything in place. So it may be some way off. But as I say, their main focus is to bring down net migration levels. In 2023, net migration stood at about 685,000. By contrast, in the 2010s, that figure was around 200 to 300,000. So it's fair to say that there has been a significant increase in that period. Labour have said they want to bring down those levels. They have said that they're not going to specify a target figure in the way that the Conservatives did. Yvette Cooper has said, look, by not setting a target, she thought that was sensible because the Conservatives had discredited the whole system by previously missing targets. They also plan to reform the points-based system, which was introduced back in 2021, or following Brexit, so that it is fairer for all and simpler. Now, there isn't a huge amount of detail at the moment as to how they're going to do that. So it's probably a watch this space. They also want to reduce the UK's reliance on overseas workers. The most common route for foreign nationals to come into the UK currently is the skilled worker visa route. Under the Conservatives, the rules for who qualifies under that route changed in April, with the minimum salary threshold rising substantially to £38,700, or the going rate for that particular role, whichever it is the higher. Also under the Conservatives, the list of jobs which someone can be sponsored for, which has a reduced minimum salary threshold, that had been made shorter, and the minimum income to sponsor someone for a spouse or partner visa also rose from £18,600 to £29,000, and the Conservatives had plans to increase that threshold even further to that £38,700 figure by early 2025. Labour have said that they've got real concerns about those increases and that they're going to ask the Migration Advisory Committee to review the change. So we'll see what happens in due course once that review takes place. That said, Yvette Cooper has said that Labour supports some further restrictions on visas, but at this point we don't know what they are. But there is still going to be some significant controls. Labour have said that they want to review those sectors which have high migration, so that would be health and social care and construction. By way of example, they want to impose new conditions on employers to draw up what they call skills improvement plans, which are there to train UK-based workers in the areas where there's high migration, so in health and construction, and improve working conditions. They've also said that once those conditions are in place, if an employer were to fail to comply with them, then one of the penalties would likely to be the revocation of a sponsor license, which is a pretty significant thing if you're a business that is looking to bring in a number of foreign nationals into your workforce. They're also considering reintroducing the resident labour market test, which the Conservative government took away. So that requires employers to show that they've tried to recruit in the UK before hiring from overseas. I sort of feel if that were to happen, almost inevitably the whole skilled worker visa process will be considerably longer, which I would question would be a great thing when we're competing so heavily for the global talent pool. But we'll see what the future holds. Under the Conservatives, social care workers were no longer allowed to bring dependents on their visa, and Labour have said that they've got no plans to change that going forward. And then moving on to the tougher penalties for employers, they want to impose a regime where the penalties for not doing things properly will be significantly greater. They've used the term that they will ban employers who flout the rules from hiring workers from abroad. So again, that would probably mean revoking a sponsor license or suspending a sponsor license. Labour have said that they want to lengthen the bans on hiring foreign workers and increase other visa penalties for employers or recruitment agencies who may be abusing the visa system or breaching employment law. So if you had an employer who wasn't paying minimum wage, for instance, then there's likely to be significant penalties in an immigration sense. Again, probably would lead to the revocation of a sponsor license. They also have made this statement that they want to pass laws to ban employers who are reliant on recruiting skilled workers from overseas as a default. At this point, it's really not clear how this will work or what they are thinking. So I think we need to watch this space. As I mentioned earlier, the Migration Advisory Committee is a body that Labour are intending to use for review purposes. For those who may not be aware, the Migration Advisory Committee is an independent, non-statutory, non-government body that advises the government on migration issues. Labour plans to strengthen the committee and establish a framework for joint working with skills bodies across the UK, and also the Industrial Strategy Council and the Department for Work and Pensions. Again, we haven't seen the detail around that, but that's the main focus of their strategy. They're also planning to commission the committee to investigate the impact for raising that salary threshold to 38,700, as I mentioned earlier. Students, moving on to students. So international students and their families have contributed to the largest increase in net migration into the UK since 2019. In 2023, there were 143,000 odd visas issued to student dependents, which was an all-time high. But the way it works at the moment is that after graduating, international students are allowed to live and work in the UK for 2 years, or if you're a postgraduate, for 3 years, by switching to a post-study work visa, so a graduate visa, which was introduced under the points-based system. Under the Conservative government, from January this year, most international students are no longer able to bring family members to the UK. Only those graduates who are on a postgraduate course, research course, or a government course, which is a scholarship, will be able to do that. Yvette Cooper has said that Labour are going to retain that position, so they're going to retain that ban on family members coming in. It's estimated that by introducing the ban, there could be 140,000 fewer people coming to the UK under that student visa route. Only time will tell whether that proves correct. At this point, Labour haven't made any comment on any review of the graduate visa itself, but that doesn't mean it won't be coming down the line. Immigration fees. So, as I'm sure many of you are aware, or all of you are aware, an applicant applying for a UK visa, in almost all cases, will have to pay some form of government fees. They will depend on which application you're making, whether it's a work application or a family application or study application. There are also fees around extensions. There's the immigration health surcharge, and there's fees around settlement and citizenship applications. At this point, the Labour Party hasn't said whether it intends to keep the levels, the fee levels and the surcharge at the current levels or not. So that's another one to keep an eye on. That's it for me. So I will go back to Justin for conclusion. Any questions?
Thank you, Richard, and thank you, Nicola, as well. And thank you, everyone, for listening in. Sorry, we've gone a few minutes over. I'm sure the others would blame me for that. But thank you all. There was quite a lot to get through. And we didn't have quite so long to prepare for this one as we usually do. But there's a lot going on. There's some lack of detail. But just a couple of things. Firstly, anyone who does want to get involved in the consultation, as I said earlier, drop us a line and we'll make sure that your views are made clear in our consolidated response. I'm just looking at the Q&A and I'm not actually sure we've got any questions, but if you pop them in there, we will respond to you individually. And finally, For those who are not known to us or us known to you, please feel free to drop us a line, make contact. We'd love to come out and have a chat with any of you who think that we might be able to help you with your employment or immigration issues. So with all that said, I'll let you get back to your lunches. We will see what happens over the next 100 days. Well, I suppose technically it's 93 days and thereafter, and we will be sending out regular updates, keeping everyone informed on what they should be doing and what might be happening. So thank you all for joining us and enjoy the rest of your days.